Thanks for that. I assume because I can hear myself that everybody in the back can hear me. So if you can't hear me, raise your hand and I'll scream louder. As you mentioned, my name is David Snead and I'm an attorney in Washington, D.C. My practice is limited to only representing internet infrastructure providers. So what does that mean? It means that I represent the people who make the internet work. I represent web hosts, data centers, registrars, registries, SaaS providers, software providers, anyone who is in the middle of an internet transaction. And what really excites me about my job is that I can see how the whole internet works, how data flows through a transaction, and that's why I'm talking about big data. Big data is one of those few issues that lawyers can talk about that really touches on a lot of different things. The other piece of my work is that with a client of mine, I co-founded an advocacy organization that advocates for internet infrastructure providers called the Internet Infrastructure Coalition, oddly enough. And we advocate for policies like privacy policies and other issues that are important to the internet infrastructure industry throughout the world. My contact information is up on the screen. Also posted on my blog, which I'll have a link to it at the end of my presentation, is the first of 2 blog posts on big data issues that will summarize or go into a little bit more detail about what I'm talking about today, so that if some of the points that I make today are a little bit rushed over, or the bullet points are not quite as dense as you would hope from a lawyer. Lawyers are always told, no more bullet points, no more bullet points, and so I try not to litter my slides with too many bullet points. It's going to be on my blog. Also in April, on my website, dsnead.com, will be 4 5-minute podcasts on legal issues related to big data. So if you don't catch everything that I'm saying today, a lot of that is going to be on my blog. So with this, this cartoon here really illustrates what I think most people feel about big data, is they don't know what it is. And from a lawyer's perspective, what is really cool about big data is that it touches everything that the internet does. So here, there are a couple of times during my presentation today where you'll hear me talk about concepts that I encourage you to remember. And the reason that big data is important and very interesting for lawyers is that it really reflects the following concepts. It reflects the collection, the processing, and the transfer of data throughout the internet ecosystem. And that is extremely important for a legal analysis of the issues that impact big data. So the collection of data, how it's collected, how it's processed throughout the internet, and how it's transferred. So when you look at big data issues, you have issues like privacy, contract issues, breach and data breach issues, termination issues, what happens to data on termination. All of these issues are very, very important and key to protecting your legal interests when you have a big data transaction. So what are we going to talk about today? This is the roadmap for my talk today. We're going to spend about 10 minutes talking about what I think big data is. Why is it important for you to understand how a lawyer looks at big data? The reason is that if you just go to your lawyer and say, hey, we have this process that we think we're going to apply to a bunch of data, what do you think about it? You're going to get a typical lawyer answer. You're going to get, it depends. Or what are you going to do with it? What you want to do is, if you try to think like a lawyer about your big data transaction, you're going to get better information from your lawyers. Also, if you're a small to medium-sized business, spending time thinking about your transaction before you pass it on to your lawyer is going to save you money in the long run. Nobody likes to pay for lawyers, and so if you spend a little bit of time thinking about your big data transaction, from my perspective, you're going to save yourself some money. We're going to spend about half an hour talking about legal issues. Why does anybody come to see a lawyer talk? They come for the free legal advice. So I'm going to spend about half an hour giving you free legal advice. We're going to talk about issues related to contract negotiation, things that you should think about when you're negotiating a contract. We're going to talk about privacy issues. We'll spend quite a bit of time talking about how to understand privacy in your big data transaction, and how the law looks at privacy, and how to negotiate the pitfalls and booby traps that are in privacy. We'll talk a little bit about law enforcement. The reason that we're going to talk about law enforcement, and I'll spend maybe 2 or 3 minutes talking about law enforcement, is because in any big data transaction, you're creating a new set of data, and you're going to be processing a huge amount of data that law enforcement is going to be interested in. And given what we know now about law enforcement's interest in data, it's really important for you to understand what law enforcement can and cannot do. At the end of my presentation, I'm going to give you 5 points that you can take back to your business, and you can say to your managers or to your CEO or to anyone else, I went to this lawyer's presentation, and here are the 5 things we really need to talk about in the next 10 minutes. So that all said, if you have any questions, feel free to raise your hands. I'm always happy to take questions. If you see something on my slide that you disagree with, whether it's a typo or something like that, let me know. And if you really disagree with me, I'm happy to argue with you, because I don't know a lawyer who doesn't really like arguing a lot. And I'm happy to get in a good argument with you about big data, because you know what, I think I'm going to win. So that all said, what is big data from a lawyer's perspective? All right, from my perspective, you start out here. You start out with an individual piece of data. Now you'll see here that I've referred to it as an individual's data. Throughout my talk today, you're going to hear me go between individual data and corporate data. It really doesn't matter. What you're talking about here is an individual piece of data. So this is one of the things that I want you to understand from my perspective. From a big data transaction, it really doesn't matter that a piece of data relates to a person or a corporate entity. It's that it's a piece of data that somebody claims that they own. It's a piece of data that somebody has a privacy interest in. So when you look at this individual data, there are 2 pieces to any legal analysis. The first is there's a private data set. So this is data that somebody wants to keep private. How do you do that? You indicate your privacy interest by setting privacy settings, or if you're in a corporate setting, you put a non-disclosure agreement around it, or you classify it as a trade secret. It's something that you consider to be private. The other piece of this is a public data set. Public data set is data that you have disclosed in some way and that you really don't have a privacy interest in. So if you look at these two data sets, this really kind of sets things up from an engineering perspective, right? Engineers like to think about things in black and white. Either something's on or something's off. And the law really thinks about it this way now, thinks about privacy this way now. It says either something's private or it's not private. But if you start to spin this out, you can see that in a big data context, this really kind of public or private analysis doesn't necessarily work, simply because in a big data context, you're figuring out how different data relates. So what we're talking about in a big data context is this. It's the figuring out the interrelationship between a public or private data set or within data within these data sets. So from my perspective, big data is the use of computing power to understand the interrelationship between data sets. It is the use of some application of some external technology to figure out what these data sets are and figure out how these data sets work. So what I would ask you here when you're thinking about this is raise your hand if you have never used Facebook's privacy settings. So there's one person in here who has never used Facebook's privacy settings. All right, raise your hand here if you fully understand Facebook's privacy settings. All right, so nobody really, oh, you understand Facebook's privacy settings.
Oh, I thought it was the reverse.
No, yeah, I know, right? I'm being a lawyer, I'm trying to intentionally be confusing, right? That way people have to pay me to figure things out. No. So no one here really understands how Facebook's privacy settings work. So if you think about this, think about how a court is going to look at this. If you can't figure out whether something is public or private on Facebook, how is a court going to figure this out? And how is a court going to figure it out when they're looking at the dichotomy between public and private data? So when we're thinking about privacy and a big data transaction, there's some things that we want to consider. The first is it's the collection of data sets. You're looking at discrete data sets and the interrelationship between those data sets. Within those data sets, you have data sets that people consider to be public. You have data sets that people consider to be private. A big data transaction requires computing power in order for these data sets to make sense. And it's your desire to understand the relationship between these data sets that have got you to your big data transaction. All right, so understanding any big data set and beginning to figure out the interrelationship. Yes?
Other than the obvious, what do you mean by a data set? Is that like manufacturing data or marketing data, or any term that we may give it? It's just somehow a category set of data?
So the question is, when I'm talking about data sets, do I mean a discrete category of data, like manufacturing data, or am I talking broadly about data as a whole? What I'm talking about is a discrete category of data. So that could be from a manufacturing context. You have a bunch of invoices that you go through and you're trying to understand how the products in the invoices interrelate to, say, your shipping times, or some shipment information that you get, say, from a freight vendor, and you're analyzing those. It's the analysis of two different data sets to find the interrelationship between them. Yes, sir?
Couldn't that data set be interpreted as kind of a non-structured data set, such as Twitter posts with a known user?
Absolutely. So the question is, does it have to be a structured data set, or could it be an unstructured data set? And the answer is it could be an unstructured data set. It doesn't have to be something that you can look at and put in a box. So you could look at Twitter using the example of a manufacturing data. You could look at how a Twitter feed relates to your manufacturing process. It's really just trying to figure out the interrelationship between these two different data sets. All right, so figuring out legal issues related to big data requires you to figure out who the parties are, who are the participants in any big data transaction are. So on the slide here, you have the 5 different categories that I would break down into the participants in any big data transaction. There are two things that I would draw your attention to here. First is my use of this term data brokers. Data brokers, that's just a shorthand term for me. It doesn't mean that in a big data transaction there has to be a sale of data. What it means is there has to be some sort of data coming from some other place. So using the example before, Twitter could be an example of a data broker. It's just some data that you're trying to figure out where it comes from. The second is this purchasers and users of data. What that means is you're analyzing the data to figure out how everything interrelates, and there's some end use for it. You're not just analyzing data for the purpose of analyzing it. So these are the parties that I would suggest that you start to look at when you're looking at any data transaction. So when we've talked from a lawyer's perspective, the key takeaway from this set of slides is that from a lawyer's perspective, big data is the analysis of discrete data sets using some piece of computing power. This right here is the computing power. It's either an analytical company or a piece of software that you buy or a SaaS service that you use to analyze data. So that's the 10-minute talk about how lawyers look at big data. From now we're going to go to the free legal advice piece of my presentation. Yes, sir.
Sorry, one more question.
Yeah.
Why are you calling out specifically the initial collection from what would be obviously subsequent collections of data? I mean, is there some primary importance to the first time you go out and get this data that does not apply to the rest?
So the question is, why am I focusing on the initial collection of data? The reason that I focus on initial collection of data, and that's a very smart question, is that in the contract analysis, in the legal analysis, the privacy interests really start with the initial collection of data. So you need to ask in any transaction, why was this data collected in the first place? What were the privacy restrictions or the ownership restrictions that were placed on this data? And how do they affect my analysis? Let's say you're 5 links down the chain from this data. If this is my credit card number, and I'm jumping ahead, but I mean this will kind of foreshadow it a little bit. This is my credit card number. I actually might have the right to come to you 5 links down the chain and say, there's something wrong in this data. You need to fix it. And you'll say, you know, we have no relationship to this data, and the legislation that governs credit reporting might actually require you to have the ability to change the data. So that's a really great question, and I appreciate you bringing it up. All right, so with the legal piece, I got to be a typical lawyer here. We're going to talk about, give you my legal analysis. As a lawyer, I have to tell you, I'm giving you this analysis for free, so you get what you pay for, all right? So if you have any real detailed questions, feel free to come up to me after. I'm going to be around all day to talk about specific use cases for you. All right, so let's talk about privacy. This goes directly to your question here. In the initial collection of data, you need to understand how the law looks at privacy. So the law looks at privacy at what is the expectation of privacy, what is the initial expectation of privacy. Again, when I use the term "you're here," I don't necessarily mean what is David Snead's expectation of privacy. I could mean what is Dow Chemical's expectation of privacy in this data. It's what is the owner of the data's expectation of privacy in it. So when the law looks at expectation of privacy, the law breaks it down into 2 categories. The first is, what is the likelihood that the information might be discovered? From a corporate context, how is this handled? It's handled by wrapping this in an NDA, right? You say, we kept this information secret, we didn't disclose it to anyone, and now we're giving it to you, but we're requiring you to keep it confidential as well. So what is the likelihood that that information would be discovered? The second piece of the analysis is, what is the discovery by a person with bad intentions? What does that mean? This goes to the breach context. This goes to a hacking context. This goes to, what if someone broke into your house and stole your computer? So a court looks at these two factors to figure out what a person's initial, or what a company's initial expectation of privacy in particular data is. Well, if you go back to my first slide where I have the public and private data sets, you can see these really aren't great analytical tools in a big data context. Because using your example, or the example that I kind of spun your question out into, you're 5 links down the chain. How are you going to figure out what someone's expectation of privacy was? So when you're trying to figure that stuff out, you need to go a little bit further, and you need to look at some of the torts that the law has created around privacy and privacy interests. So in order to help you remember these torts and the torts that we're going to talk about in terms of expectation of privacy, we're going to talk a little bit about Facebook, very briefly. As I mentioned before, Facebook has privacy settings. The reason that I use Facebook as an example is not because I don't think anybody here is going to be doing any analysis of Facebook data, but it's because Facebook has created whole categories of data that you want to share with people or that you want to keep private. So if you go back to this slide, you can see that you can start to analyze how in your Facebook privacy settings you might have expressed the likelihood that data would be discovered, or if in a breach context, how data might be hacked into. The way to think about the tort system and how torts might be, how torts might fit into this is by remembering Randy Travis. So here we have a mugshot of Randy Travis after his DWI. How many people here think that this mugshot should be private? So we got maybe 3 or 4 people who think that Randy Travis should keep this should be kept private. This is when I typed Randy Travis into Google when I made this particular slide in September. This was the second thing that came up in Google. So if you were Randy Travis, you'd probably be pretty interested in having this information remain private. So Randy Travis, if he were looking at suing mugshots.com for posting this mugshot, he would start looking at the different torts. What would he look at? Disclosure of private facts. This is the tort that's been created around this issue of likelihood of discovery or hacking. You'd also look at intrusion on seclusion. In this case, Randy's not really tried to hide very much that he's been arrested because he's been he's actually in custody. But this is the second tort that a court would look at. The final thing is, what type of privacy agreements are there? Well, in this case, because the law has created an exception for mugshots, there are no privacy agreements related to mugshots. So why am I talking about torts and the torts related to privacy? It's because it's important for you to know that those two factors, the likelihood of discovery or the likelihood of discovery with someone with bad actions, aren't necessarily going to be dispositive. What is the most important thing for you to think about? It's this: privacy agreements. Most people here are here from a corporate standpoint, and you need to think about privacy and privacy agreements and what people are going to say. So what we're going to do now is we're going to dive into what type of due diligence you need to do in order to conduct a big data transaction, looking specifically at privacy and privacy agreements. So the categories that you need to think about when you're looking at due diligence is, what is personal information? Again, when you look at what is personal information, you're looking at what does somebody want to keep confidential? What has your business put confidential information around? First thing you're going to look at is the privacy policy. What does the privacy policy say? So, as I said before, there are going to be a couple times in my talk today when I'm going to stop and I'm going to say something that I want you to pay particular attention to, and it's this. Privacy policies are contracts. If you breach a privacy policy, you've engaged in a contract breach. You can be sued for that breach even if you are 5 links down the chain. So it's very important for you in any big data transaction to ask your vendor or ask whoever is providing you with this personal information, I need to see the privacy policy that underlay the initial collection of this data. Remember, the first piece that I asked you to remember is this phrase, the collection, processing, and transfer of data. What does the privacy policy say about the initial collection of that data? You go from there and you figure out what was the initial expectation of privacy. From a corporate standpoint, what did your non-disclosure agreement say? Did you create trade secret protection around this? Or from a customer's expectation, what did their Facebook settings say? You go from there and look at what the larger contract says. How is the data collected? Are there warranties? Are there representations that you need to think about? What does the contract say? And finally, you look at what does the law say? Are there any regulatory, any regulations, or any other issues that you need to think about? So, let's move on to what does the privacy policy? Yes, sir.
Just a question.
Sure.
Been seeing movement to more and more things being considered personal information, right? The IDs that we use in our company, right? Our email IDs, right, are now being treated as personal information.
Okay.
And I'm just curious if there, it seemed before it seemed to be a much more narrower, like, social security number, date of birth, very concrete things.
Right.
It seems like it's growing much wider. I just don't know if that's misperception or truth, and where does it sort of stop?
So the question is, what is personal information? What is personal information?
I see the boundaries of that growing.
Right, it is growing. It is growing because the view in the U.S. is shifting from the typical U.S. view of name, social security number, gender, date of birth, and that type of identifiable information to the broader category that honestly the rest of the world uses, which is anything that might be about you as a person, that might identify you as a person. So I would suggest that the category of what might be considered to be personally identifiable information is actually growing. So I'm going to go through this a little bit more quickly here. So you're looking at privacy policies. Here are the factors that you should think about when you're looking at privacy policies. The important things for privacy policies are these. Does it cover transfer to third parties? If you see a privacy policy that says something like, we won't sell your information ever to anyone, you really need to be afraid of engaging in a big data transaction with someone whose privacy policy says that. Second is, does it require permission? Was the initial collector of the information or any of the subsequent transferors required to get permission to transfer it to you? And what does the privacy policy say about that? The next issue is, what are the privacy expectations? Since I've spent about 2 whole minutes talking to you about privacy expectations, I'm going to assume you're all experts here. But looking at privacy expectations, you're going to want to look at a bunch of these different factors. Of these factors, the two that I would suggest that you focus on are the initial reason for collection. Was it collected, for example, using your question, was it collected for human resources purposes? If it's collected for HR purposes, you're going to want to know, or you're going to think that it might actually be a bit more restricted than other data. Second is, what type of data is it? This kind of goes to that question again. Is it HR data? Is it something that, as a reasonable person, you might be upset about if it was disseminated about you? Or if you're a corporate player, is it information that might be a competitive advantage for your business? Something that would be actionable if it were stolen from you. So, moving on to the contract. This piece of, yes sir?
On the initial reason, so like a bank, you go and apply for a credit card or something.
Sure.
So you fill out an application, and there is this disclaimer there, and you have to sign the waiver,
Right.
because they are going to do some due diligence on your background, credit histories, other things, right?
Right.
But that's very open-ended. It's not. It doesn't say that we will run your credit report. It's a general purpose that bank is authorized to do some kind of due diligence on you.
Right.
So how does that initial reason kind of box it in that, okay, initial reason is this, and it's not just an open-ended year-over-year investigation of whatever they think is that?
So the question is, and tell me if I'm summarizing this accurately, if you look at the initial collection and it's very broad, does that box you in the future? Is that
Correct, yes.
okay? So that's why you look at the initial reason, right? So if you're a bank, quite honestly, if you have ever looked at a privacy disclosure from a bank, it essentially says we can do whatever we want with this information as long as we're not prohibited by law from doing anything to it. So if you're five links down the chain and you look at that policy and you say, all right, well, we're going to use this person's the decision made about this set of loans to figure out whether or not we're going to sell, we're going to market to them, and you look at the initial disclosure, you can say, yeah, it looks like this person, when they gave the bank this information, they agreed that it's that they don't have a privacy expectation in it, or that we can use it for this purpose, right? So you'd actually look at it. And that actually brings me to this point, and it's, what does the contract say? In any big data transaction, you're going to want to do a 360-degree contract review. What does that mean? It means you want to look at all of the contracts that have been used to process the data and collect the data that preceded you, and you want to look at all the contracts that are going to be used subsequent to your use of the data. You actually want to use this data. Let me ask you this. Yes?
I was just going to ask, do you see a move in sort of contracts towards privacy indemnification, right? Like, right, liability, we do the same thing. Hey, I can't do everything you've done, so I will just say you're responsible for it.
Sure. So the question is, do I see anything regarding privacy indemnification? And the reason I was smiling is, this is one of the most engaged and thoughtful audiences that I've had on this topic in a while, because you're actually anticipating what I'm going to talk about in a couple slides, and that is indemnification. That goes right to the heart of this particular slide, actually, and it's, if there are indemnification or warranty provisions in prior contracts, you need to make sure that you're not going to be held liable for them. It goes to your question that if you process data from this bank and you're processing it in ways that contradict the initial collection, you might actually be on the hook for that violation of that contract. So it's very important that you look at the contracts, you look forward and you look backwards. So you want to look at regulatory agencies. Is this, for example, loan information? You're going to want to figure out which regulatory agencies might apply. You're going to want to look at whether or not you have to review a specific state. A lot of states now have their own privacy regulations. Also, if you're outside the US, the European Union has very specific provisions related to privacy. So after you've done your that's spelled wrong. After you've done your 360-degree privacy review, you're going to want to look at the different agencies here. So the first is the Federal Trade Commission. The reason you want to look at the Federal Trade Commission is this privacy policy. You want to figure out whether or not you're violating a privacy policy. Again, privacy policies are contracts, and if you violate them, the Federal Trade Commission is going to come after you for violating a privacy policy as an unfair and deceptive trade practice. You're going to want to look at FCRA, and we're going to talk about, I'm going to very briefly mention some agencies that you might not have thought about. This is this point that I was making about changing credit information. FCRA might apply and gives people the ability to change information even though it might be 5 links down the chain. A lot of states have implemented do not track legislation. The European Union just yesterday, the Parliament passed a regulation that creates the right to be forgotten. So you might want to think about do not track and these other issues. You want to think about Gramm-Leach-Bliley. To the extent that you are involved with a publicly traded company or you're processing information that might be subject to the Securities and Exchange Commission regulations, you need to think about Gramm-Leach-Bliley. And finally, everybody's favorite set of acronyms, HIPAA and HITECH. These are healthcare regulations, and they have 18 different data factors that give users the ability to access data. So these are the agencies that you need to think about. All right, so let's roll this up. The things you need to think about. How has personal information been defined, or is it confidential? You need to look at the privacy policies. You need to figure out what the expectation of privacy is, what the settings say, what the privacy policy says. You need to do a 360-degree contract review. Finally, you need to figure out whether you're within a particular agency's jurisdiction or not. All right, so let's talk very quickly about law enforcement access to data. Law enforcement access to data, I will leave you with one statement here. It's a typical lawyer statement. Law enforcement has to have a warrant to access content. I'll say that again. When the police come knocking on your company's door, they have to have a warrant to access the content unless it's only customer information, customer identification information. That's the typical Geneva Convention stuff that you hear in World War II movies. Name, rank, and serial number. That would be the customer name, their address, the IP address they use, payment information, and that type of information can be received with a subpoena. So I'm going to have to blow through this because we're kind of running out of time here. But if you want to talk to me about law enforcement access to data, I spend a significant amount of my time interfacing with my clients in law enforcement, so I can talk about law enforcement access to data until the cows come home, quite honestly. All right, so we'll talk about contract issues here. Here are the contract issues that I think that you need to think about in your 360-degree contract review. You need to think about warranties. What warranties were made about the data, what warranties were made about access to the data, and how the parties looked at them. Second are you required to indemnify anybody for access to that data? Are you making any indemnification obligations? And what type of indemnification obligations did people make 3 links down? So what I'd like you to do right now is, I'd like you to imagine a big soapbox right here. I'm gonna step on my soapbox and I'm gonna make a very brief statement about warranties and indemnification. Do not take a contract and circle the warranties and indemnification provisions and write "make mutual" on them. In a big data transaction, you actually need to know what uses you're going to make of the data, how the data is going to be used, so that you can actually look at the warranties and indemnification provisions and ask for specific warranties. Ask for a specific warranty about ownership. You want to ask for a specific warranty about use. Indemnification, you want to be asked to indemnify for violations of privacy policies. Ask for specific things, not just generally to make the warranties and indemnification provisions mutual. Again, you need to think about data collection, processing, and transfer. I've talked a bit about that. Finally, you need to think about what happens to data on termination. Once a contract ends, the parties' rights and responsibilities to that data or in that contract end. So if there's a breach of data, if you're sending data to a processor and there's a breach of data and you have an obligation to your customer, you need to make sure that your vendor's liability did not end on termination of your contract. All right. Looking at regulatory issues, you need to. I would look at these 2 data points right here. Figure out what data breach means. Look at the law and determine what data breach means. Understand that the term breach does not have a legally defined meaning. So in the contract, you need to know what data breach means to you. Finally, you need to figure out whether data is going to leave the US. The US has an almost completely unique view of data processing in the entire world. Do not assume that our societal views of data and data processing apply throughout the world. If the data is going to go outside the US, you need to understand where it's going to go and the regulatory regimes that apply. So in the next minute that I have here, here are the 5 things that you can take to your managers and talk about immediately. First is, how are we going to get notification of a breach? When is that going to happen, and what does breach mean to us? We need to engage in a 360-degree review of the contracts that are involved in this big data transaction. We need to look at the privacy agreements. What is going to happen to this data when the contract ends? Is it going to be deleted? And what are the rights and responsibilities of the parties in that data on termination? How is the data going to be collected, processed, and transferred? Do we understand how this is going to work so that we can ask for accurate warranties and indemnification provisions? And finally, how will we gain access to this data if somebody needs to change it? For example, if you were governed by FCRA, Gramm-Leach-Bliley, or HIPAA and HITECH. So these are the 5 things that I'd suggest that you take away. Here's my contact information. This is my where my blog is. My blog. It's on theword.com. If you can't remember the acronym, it's the Web Host Industry Review under blog. I tweet and I talk about these issues quite a bit, and it's something that I'm very interested in. If you have any questions, I'm always happy to answer them. But more importantly, I really appreciate everybody coming. Does anyone have any questions just before I wrap up? Yes, sir.
You wanted to go back to the last slide.
Sure, yeah. I'm sorry, I'm being told that I have to stop, so. Do you have, yes, sir.
Everybody's gonna be hungry, right?
Yes, sir, you have a question?
Who owns the content of your tweets?
Who owns the content of my tweets? Twitter does. Yes. I agreed to that when I signed up for Twitter. They don't own the content of my links in Twitter, but they own the content of my tweets. And thank you for reminding me who owns my where I work product. Again, thank you all for coming. I appreciate your interest in legal issues. I'm around for the rest of the conference, but have a good conference and thanks for coming.
We now have an hour break for lunch. Scott, where is that? What room is that in, do you know?
That way, take a big left. Over there.
Okay, that way and left.